Hello everyone, this is Borona Africa Tube, and that's the beginning of the discussion on the Ethiopian law of succession. So in this video we're gonna begin and discuss some pointers of from the course called the Ethiopian law of succession. And before starting the detailed discussion, it is really important to understand some basic concepts and terminologies which really help us to master the course easily and to make the course called the law of succession quite easy. So having this understanding in mind, it is better to carefully follow those terminologies and the basic concepts. So first, the law of succession is the branch of law which is fall under private law, and it governs the manner or the way in which and also to whom the rights and the duties that a person acquired during his lifetime pass to the rightful successor. So that person, the rights and the duties which transferred from the deceased to the rightful successor is those rights and duty that is acquired by the deceased during his lifetime. So now let me tell you the contents of the course so that it will suitable or it will be easy to understand. The course is divided into three basic chapters. The first chapter is all about the devolution of succession. By devolution of succession, we mean that it is the process. It is the process by which a deceased person's state is passed on to their personal representative or to that of the rightful successors. It is all about the process. The second chapter is about the liquidation of succession and the determination of rightful successors. By liquidation, we mean that it is the process of selling an estate after someone passes away. In liquidation, there are different activities that will be done. For example, identification of the rightful successors, or the fact that who is entitled to inherit the properties of the deceased person, and other things, other activities will be made during the liquidation of succession, and we will discuss these concepts under the second chapter. And the third chapter is all about the partition of the succession. So having this understanding in mind, it is better to begin the first chapter, which is all about the devolution of succession. And this chapter is divided into three sections. The first one is the general considerations of the devolution of succession. The second one is intestate succession, and the third one is will. So now let me tell you some important things here. As we know, or as it is clearly stipulated under the first article of the Ethiopian Civil Code, the rights and duties are held by human person from his birth to his death. So, the law of succession is also all about the devolution of those private rights and the duties of the deceased person, which that person acquired during his lifetime from his birth to his death. The law of succession deals with the rules which apply to the division or the distribution of the estate of the person when they die. So the applicability of the law of succession comes into the picture at the time, especially at the time when the person died. Then, as I said, this law belongs to the private law category. So Now, let me see, let me tell you some important terminologies from the first chapter specifically. Those are the terminologies which really help us to easily understand the course and which everybody, every law student, or especially the students of the law of succession, must know or expected to know. The first terminology is that of patrimony. By patrimony, we mean that traditionally it is related with the property which is inherited from the father or the male ancestors, but in the law of succession, it includes both the property which is inherited from the father or male ancestor and also the mother female ancestor, since our constitution 1995 constitution under article 25 clearly stipulate and ensure the equality of everybody, every human beings. The second term is the deceased. By the deceased we mean that someone who is no longer living or the dead person. The other important terminology which is intrinsic to the law of succession is that heirs. Heirs are those persons which are legally entitled to the property or rank of another on that person's death. The one who have the full right, who entitled to take part in the devolution of the succession of the deceased person. And the other one is legatees. When we say legatee, it is a person also who receives the legacy. Who receives legacy. What does it mean by legacy? Legacy means that a property or money that's left to someone else in a will. The deceased or may made a will during his lifetime before his death. And those person who receives legacy or an amount of money by the entitlement given to him by the will made by the deceased is called a legatee. The other one is what about the residence? When we say residence, we are talking about the place where one actually lives. To have a better understanding of residence, to differentiate it from domicile, it is better to refer the civil code. The other one is inheritance. By inheritance we mean which is all of the property which were owned or possessed by the deceased on the day of his or her death. Right? All the property, movable, immovable, money or in kind or in cash, which owned, possessed by the deceased person, by the one who died at the time of his death, is considered as inheritance. The other one is that of hereditary estate. What does it mean by hereditary estate? By hereditary estate we mean that the all inheritable property left by the deceased at the time of his or her death. All inheritable property. Inheritable property. All properties are not inheritable. So, all the properties which is inheritable are called hereditary estates, and inheritance is all property which is possessed by the deceased person before liquidation, we can say. The other important concept that everyone must know is that what does it mean by survivorship? Survivorship. This means the condition of being survivor. Survivor. What does it mean by survivor is that a person remaining alive after an event in which others have died. So, this is survivor means the condition of being survived. the condition of being alive after the death of the other. The death of the other. And then the other one is the basic, the Latin terminology which related with those. Survivorship is that of Comorianus.
Corona Africa, the friend of everyone. Ege, Corona Africa, Minto Nalonda, Aho, Corona Africa, Yehulum Guadoni.
By Comorianus meaning that, which is a Latin word as I said, and it signifies those who die at the same time. Sometimes people may die simultaneously. It may be because of accidents, like car accidents, and those persons may otherwise to each other in these circumstances. And then Comorianus mean that it is the word signifies those who die at the same time by accidents, and when it shows the situation when it is difficult to identify who died first. If those individuals died by accident, for example car accidents, sometimes it is really difficult to identify who died first. So this term Comorianus, this Latin term Comorianus, show these facts. The other one is really important to the law of succession is that of unworthiness. What does it mean by unworthiness or being unworthy? This means lacking the necessary qualities to deserve something, lacking the qualities to take part in the division of the succession, in the devolution of the succession. This may result from the act of the heirs or the rightful successor himself or herself. So we will discuss in detail. But now, what I am making that I'm trying to make the term itself clear. So once we understood the meaning of the terminologies, those important terms, it's quite easy to understand the detailed discussion on each concept. The other one is tested succession. Tested succession is a succession that is made based on, depending on the valid will made and left by the deceased person. So, which is tested succession. In case of tested succession, we're gonna devolve the succession based on the rules written down by the deceased person itself. When we come to the intestate succession, this is a time. This intestate succession come into the picture at a time when the person, the bearer of the rights and duties, died before pouring or writing the will. At that time, intestate succession come into the picture, which means evolution of the succession, which is made by the court as per the law. And the other one is strat. Strat being the reversion of property to the state upon the death of the owner, when there are no heirs at all. When this is sometimes, though it is rare, the deceased may have a rightful successor, the successor. At that time, the property will come to that of the state, because there is no one who claimed the property. So state means the unclaimed property of the deceased person. So at the end of the day, if there is no one who claims the rights from the deceased person, the property will come to the state. The other one is representation. Representation means acting on behalf of someone else, acting on behalf of the other person, which is called representation. representation. And the other important term is in the law of succession is that of renunciation. Renunciation means that it is leaving one's share in the succession, leaving one's share in the succession. This means refusing to take one's share of succession, even if he or she is a real heir, but not wanted to take succession because of different reasons. So when we talk about renunciation, we are talking about refusing to take one's own share, so that even though the person is the rightful successor, sometimes there are people who refuse to take their share. This may be done because of different reasons. For example, that individual, if there are three peoples, or if there are three heirs, three rightful successors, and one of the successor one of the heir may reach and they may not want to take part in this devolution of taxation, and he may renounce, he may leave, he may refuse to take that. The other one is will. By will we mean that it is a situation in which the starter determine how his property should be devolved, how much to whom, for legal heirs or non-heirs can be. So will is the law which made by the starter, which made by the deed itself, as to how his property should be devolved, how much, to whom, everything decided by the testator. Once we make sure that the will is valid, the devolution of succession will be made as per the will itself. Say. And the testator is the one.
Yeah.
Who made the will, and when we say revocation of will means that making the will not have an effect in different way. So the other important terminology is that of desertion. Desertion means making an heir not to take any part or portion from the succession, or giving a very small portion of legal heir. Desertion is making the rightful successor not to take part or part of that from the succession, or giving a very small portion. Giving a very small portion to the successor is amounts to desertion. This desertion can be made because of the act of the successor itself by the testator. And then here, desertion, when we say it is just making an heir not to take any parts, zero. Or, for example, if the deceased person or the testator may have, around 4 million liquidated property, and if he had 3 children, and if he give in his will 2 million per for 1.8 or 2 million per for Mr. A, let's say, and 1.9 million per for the other, and 100,000 per only, or 2,000 per only for the third. This is amount to desertion, giving it a small amounts. So this is all about the important terminologies. That is really important to have a better understanding of the discussion that we're gonna make in the future. Then what is our objective? Knowing objective before beginning or starting the detailed discussion is also really very important to know how to read, how to learn. So upon completion of this chapter, every one of us expected to decide which rights of the deceased shall be transferred to the heirs upon the death of the deceased. Because every right is not transferred to the heirs, to the rightful successors, and advise people the things that make up inheritance. Which things? That everything is inheritance? No. Pass judgment on which person have capacity to exceed the list. Identification of capacity. Explain the importance of the concept of representation. Disqualify wills that are not made according to the requirement of the law, and evaluate whether the reasons given by the testator to disinherit his children justifiable or not. Those are the basic important things. And section 1, general consideration of the devolution of succession. We will discuss these concepts, or we'll start the discussion on this point on the next video. If you like the method of delivering the lecture, show us by liking the video. And if you have any comments, corrections, it is better to write it under the comment below. And don't forget to share it for your friends and to subscribe the channel so that we'll make other bad videos on other law courses. Thank you.